I want to thank the Chamber for inviting me, and I'm very happy to make this presentation. And I think it's important that our people understand the importance of estate planning and wills and things like that. So my law firm, we've been practicing for about 25 years. We started off in a big law firm, and then we split about 23 years ago in that range. And then we have a smaller group. We have even though it looks like a lot of things we do, we specialize in a few things. We don't do employment law. We do any kind of very complex litigation because my partner, Terry Morgan, he's also an engineer and an attorney, so am I. So anything complex we handle, but we're courtroom lawyers too. We do litigation, we fight for our clients in the courtroom. Family law, probate. Probate is a broad concept, and I'll explain that in a few minutes. Criminal defense, contracts, and of course patent, trademark, things like that. That's a very specialty, only a few lawyers do that. So we are a law firm we have some specialists in our law firm. We have, for example, one attorney who does nothing but family law. We have another attorney who focuses only on probate. I do the courtroom and some of the family law and the probate. I get involved in all of this. I draft some of these documents. But if there's a courtroom fight, I'm one of the leaders in the law firm that will go to the court. So that's another reason, if you plan early, you could avoid a courtroom fight, because probate litigation is very expensive. And once a person passes away, things that they intended is not happening. People are fighting, creditors are coming, sometimes beneficiaries are fighting with each other. And a lot of the money that's in the estate is thrown away in litigation. So there are some ways to avoid these things. So today the topic is probate matters. So let's get started with your permission. So why do estate planning? The primary reasons are, we worked hard for everything we have, so we want to make sure we provide for our loved ones. We mitigate avoiding probate process. Probate process means there's a lot of things that can happen when somebody passes away or something happens to somebody. Then there could be litigation, there could be courtroom things, so there's a lot of things that will happen. So we want to mitigate and just avoid a lot of those expenses. Taxes are a big thing. There's a lot of taxes. Orderly administration and stewardship of property. So you want to decide how your assets are going to be handled. You want to have full control of that even after you pass away. Well, you can make some documents that will make your wishes come true on how this is handled. So you protect your asset, and then providing for incapacity. Incapacity means something happened to you. You cannot make a decision. Maybe an accident, maybe stroke, maybe something, dementia. Something happened, you're no longer legally available to make decisions. So those type of things we have to plan for. So what are probate matters? Probate matters is a very general term. It includes wills. And how do you have a will in Texas? I'll discuss more details about a will. A will has to be in writing. It has to be signed by whom? The testator. Testator means the person who's making the will. If this is your will, you're the testator. Either you sign it, or you get somebody to sign on your behalf if you're physically unable to sign it. Then you get a person to sign on your behalf in the presence of the testator and under the direction of the testator. And the other requirement is it must be attested by two credible witnesses. That means two witnesses have to witness this whole thing. They have to be present. In their handwriting, they have to sign. Okay, so not DocuSign or something. They have to be there. This is what's required in Texas to have a valid will. So you have wills, you have estate issues, which is kind of general. Something happens to you, then the estate needs to be handled properly. Even if you have a wife, if something happens to you, there's an estate and your wife is a separate estate at that moment, legally, unless you have a will. Go ahead.
No, I thought, your next of kin will automatically in charge of the estate and your.
No, it's not that simple. So what happens is, if you die, it's intestate. That means you don't have a will. Then there's some automatic laws that come in. First, your children will get part, like Texas is a community property state. Okay, so if you die, then your wife has half interest in the entire community that you own. Everything you own everything you made during your marriage, that belongs to the community. It doesn't just belong to you. So she will have half interest, you will have half interest. If you die, then she doesn't have control of your half. There's some laws that happen. If you have children, then it can be controlled by that. If they don't have children, then next of kin, she can lose control of your half. So even in the house you're living in could become a problem if you die without a will.
No, the witness you said, the witness could be part of a family member.
It can be, the Texas law is very relaxed about the witness. It even says somebody over the age of 14, I didn't put that up there. That's not advisable. You want an adult, it's better to have outsiders. And so when we do our will, what we do is we bring you guys into the office during the execution. That's another thing. Getting a will done, you have to be very careful. I always recommend, if you don't use us, use some attorney. And the reason is there are some steps that need to be properly taken. There's a will signing ceremony, there's all of those things that the attorney has to have said, the witness can attest to that. If those things don't happen, if there's a fight over this, it can be a problem. Okay, so what we do in our office is we'll have some of my staff will be a witness. One of my staff members will be the notary also. So you have an independent third party who's not related to you. That's what I would recommend. Better not to bring your kid, your son or daughter.
Thank you.
So, one more question.
Sure.
So you said that if the person who initiating will, if that person cannot sign, someone else can sign. Who's that someone?
They can assign any adult, any competent adult, because maybe they physically cannot sign, but they can direct somebody to sign, but they have to be present.
So who witnessed that or who can assign?
And the two witnesses have to be witnesses only. Okay? If you guys use us, then we will make sure all of that is done properly. Right? So there won't be any issues. Issues come up later in court, and that's when all the problems will come out. So probate matters, you have wills, you have estate issues, you have trusts, and we'll talk about trusts in a little bit. And then you have something called guardianship. Guardianship is when someone is incapacitated, then you can apply, go to the court, and become their guardian. For example, if you have so if you have one of your elderly parents, suddenly they have some dementia or something, you can apply, go to the court and apply for guardianship. Now you have to go to a medical doctor and they will have to do an examination and fill out a medical report. And you file that with the court, then you can gain access to their interest. Now there's two types of guardianship, we'll get to that. So guardianship is another whole thing, or sometimes, unfortunately, നമ്മുടെ community related to the handicap, development issues or whatever. So once they become an adult, you got to make sure you are a guardian. You have guardianship. You're automatically a guardian of your kids. They're underage, that's no problem. But once they become 18, if there's a problem, then you have to, because you won't have control over, and then the state could come in and all kinds of problems could happen. So those are the main things about probate. Those are the issues. If not done right, there will be litigation. Us attorneys don't mind doing litigation, but it's too expensive.
So the guardianship is different in each county, is that right? The guardianship process?
No, it's a Texas law that applies here. So you would go and file it in the county that you're residing in. So the laws will be the same, but you have to go to the court in that county, so.
The process is different or the process is same in any?
It's the same. It's the same. It's just that some courts, the law is the same, but some judges have their own. If you live in Montgomery County, for example, that's a rural county. They run things a little differently, and the judge over there may not specialize in probate. See, in big counties like Harris County, and even in Burbank County, there's specialty courts. They're all district courts or county courts, but some will handle family law, some will handle probate law. But in small counties, one judge could be handling many things. And that's not really a good thing. But, so it's a county by county, but the law is the same all over Texas. So that's the main general things about probate. So let's talk about wills. So everybody says, oh, എനിക്ക് will ഉണ്ടാക്കണം, എല്ലാവരും ചിന്തവരും will ഉണ്ടാക്കണം. So there's a lot that goes into it. It has to be done correctly. And that's why I recommend that you use an attorney to do it. Whether you use our firm or any other firm, but go to an attorney that handles that. Because there's a lot of little things. Usually, maybe there's no problem. Maybe it's a simple will and nobody challenges anything, it goes through, but problems happen. Creditors can come, somebody else will assert a right. If there's a business, then maybe there's a business partner or somebody, who's an investor. I mean, there could be a lot of things that could happen. So I would recommend, going to an attorney and do it very correctly. And when we do a will, we don't just draft one document and call it will. We have what we call a wills packet. So we have 7 different documents that we produce for our clients. So let's talk about each one. The main one, the first one is the last will and testament. That's your main document. This is where you lay down, what you own, how you want to distribute it, whom you want it to go to, 25% to the kid, 25% to the spouse, or, whatever else, however else you want to do it. The way you want to do it, we will draft it like that. And it has a lot of details. It's a big document. It has many parts to it, and we don't need to go through the whole thing. When we sit down, we can do that. But that's your main document, the last will and testament. That's what a lot of you guys will just go and have it done by somebody, you just got that one. But there's a lot of other things that happens. There's a document called revocable transfer on death deed. This is a good way to protect your spouse. So we can file this with the county. So you can have a transfer on death deed. So the minute you die, the spouse or whomever you name will get your interest in that house. So the problem is, let's say you have a $700,000 house, you die, and you don't have a will. It could be problematic because suddenly there's an estate created. Now you have to go to court, and how that's going to be distributed. The judge wants to make sure that all the people, beneficiaries, potential beneficiaries are contacted. So if you have children all over the United States, they have to be properly noticed, served. So all kinds of things happen. But if you have this document, immediately your wife gets the whole thing. She's in full control. There's no turning over. If she needs to sell the house immediately, no problem. Because now she owns it completely without having to go through all that. Otherwise, it'll be months and months before she can do anything with it. He or she can do anything with the house. So that's revocable transfer on death. So we will do that. There's a declaration of guardian. So this is kind of a nice thing to do because most of the time the spouse will name each other. So if something happens to you, you have a stroke, and you're incapacitated, you appoint your wife to be the guardian and she can take control. So she doesn't have to go through all of this process. So declaration of guardian. HIPAA release is also important now. Even with spouses, it's hard sometimes to get medical records. In the middle of a crisis, you're in the hospital, you need emergency surgery, but you need some other documents from the previous doctor, the scan. It may not be that quick to get it. You have one of these, it's very fast. So we'll do a HIPAA release. directive to physicians. This is what you want. If you can be revived, then you want treatment. If you cannot be, or you can put down what you want. This is, some people call it like a living will. Directive to physicians. This is another thing we'll draft for you guys. And then the medical power of attorney. This is a lot of times the spouse will name each other to take control of. We have നമ്മുടെ മലയാളിയിൽ ഒരു ഇൻസിഡന്റ് വന്നാൽ ഒരു ഡെന്റിസ്റ്റും മരിച്ചു പോയത്. There was a case. Who decides? He was in the middle of a divorce, but the divorce is not there yet. So she has superior rights. The son is involved. His brothers are involved. They go to court. It became a huge issue. Meanwhile, he's on the machine, just days after days after days. Then the judge finally heard all of this, and I think the last thing was he gave the right to the son. So, but think about what all happened during that. In the middle of this, somebody's dying, and how much fighting there was between the brother, the family, the wife, the son, everybody's involved. Okay?
The will has to be made by both parties or a single party can do it?
So when we do the will, we do two separate wills. You sign your own will, your wife will sign her own will. And in her will, a lot of this, you'll be named. In your will, she'll be named.
So it's a two-party will.
Two different parties.
So as such, we have to be separate, whatever the belong. I have whatever the buying account or retirement plan have to be mentioned both.
So retirement is a little separate, but yes, assets generally have to be. Now you can make some general statements. All my assets I'm giving it to my wife. You can make statements like that. That'll cover a lot of things. Retirement accounts generally, when you set up your retirement account, you put a beneficiary there, right? So that'll go smoothly.
So is there any effect on?
Yeah, we keep the retirement stuff out of this. Because that's a separate deal. It doesn't have to be probated.
എനിക്കൊരു ക്വസ്റ്റ്യൻ ഉണ്ട്. അതായത് നമ്മൾ അമേരിക്കയിൽ നമ്മളൊരു പേപ്പറും വീട്ടിൽ വെക്കേണ്ട ആവശ്യമില്ല. പാസ്പോർട്ട് നഷ്ടപ്പെട്ട പാസ്പോർട്ട് ഉണ്ട്. വണ്ടിയുടെ ടൈപ്പ് നഷ്ടപ്പെട്ടു കഴിഞ്ഞാൽ വണ്ടിയുടെ ടൈപ്പ് കിട്ടും. നമ്മുടെ വീടിൻ്റെ ഡോക്യുമെന്റേഷൻ പോയാലും അതിന് ബാക്കപ്പ് ഉണ്ട്. ഈ ബില്ലെന്ന് പറയുന്ന സാധനം ഒരു അറ്റോർണിയും ഒരു കസ്റ്റമറുമായിട്ട് ഉണ്ടാക്കുന്നത്. അപ്പം ഞാൻ ഒരു ആളിനോട് ഇതിനെക്കുറിച്ച് ചോദിച്ചപ്പോൾ പറഞ്ഞു എൻ്റെ ഒരു കോപ്പി ഉണ്ടെന്ന്. ഞാൻ പറഞ്ഞു നമ്മൾ രണ്ടുപേരുടെ വീട് ഒന്നിച്ച് വെള്ളപ്പൊക്കത്തിൽ പോയി, രണ്ടുപേരുടെ കയ്യിൽ നിന്ന് കോപ്പി പോയി. What kind of resource we can put?
Yeah, that's a big problem. So what I would do is this. I would give one copy to the attorney, and we keep electronic copies, and then we are on the cloud. Okay, so our data is stored on the cloud. So almost we should have at least a copy. But that is a big deal. Actually, you want the original. Sometimes we'll make two originals.
I would say at home,
Have a safe.
വീട് ഫയറുണ്ടായി, എല്ലാം കത്തിപ്പോയി. എന്ത് സാധനം വേണമെങ്കിലും നമുക്ക് റിക്കവർ ചെയ്യാം.
വില്ലിച്ചൊരു പ്രശ്നമുള്ള
അതുപോലെ ഈ വില്ലിന് എവിടെയായാലും നമ്മൾ എവിടെയെങ്കിലും ഡേറ്റാബേസിൽ നമ്മളത് സേവ് ചെയ്യുന്നുണ്ടോന്നാണ്.
We don't register anywhere in the company.
No. No, we don't register in the county. You should give it to your lawyer. You should put it. But നമുക്ക് എല്ലാവർക്കും ഒരു ഇത് deposit, safety deposit box ഉണ്ടല്ലോ. So you should put that in there.
I'd say that you put the USB and put it in the
Yeah, you can make a couple of copies, but the problem is copies are, if it goes to litigation, but it'll work. It becomes a little harder, but that's when the witnesses will help. The witnesses can come in and test. So that is true. It's not. Even നമ്മുടെ പാസ്പോർട്ട് പോലുമല്ല ഇത്. You have to maintain that somehow. So you can buy these fireproof safes. Fire ഉണ്ടായാലും that should be okay.
Any natural calamities will take care of if you have answer to these things.
എങ്ങനെ?
Any natural calamities,
Uh-huh.
like a fire, hurricane, whatever it is. So if you have an iron safe at home,
Yeah, especially if you bolt it down to the.
Yeah, bolt it down.
Bolt it down, yeah.
Or create a new one, right? A new.
If you're alive, but if you died in that natural calamity, then there's a problem. There are problems with that. ജീവനോടെങ്കിൽ നമുക്ക് പിന്നെ ഉണ്ടാക്കാം.
I said, "Pulling it down. That's cool."
Most of this medical stuff, especially the medical power of attorney, if you give it to the hospital, once they are in the system nowadays,
Yeah,
they have.
yeah. The medical power of attorney, they'll keep it.
Yeah.
That hospital will keep it. Yeah, that's true. And then there's what's called the durable power of attorney. Now, this one's pretty important, okay? So you can make a power of attorney for anything you want. A power of attorney, you can make a general power of attorney. I don't recommend that. You can make a power of attorney for your finances. You can make a power of attorney to sell a house. You know, you can do anything. Durable power of attorney, though, it's kind of a general power of attorney. You can limit it the way you want. Durable power of attorney means something happens to you, you become incapacitated, that power of attorney survives and is still in force. So durable power of attorney so you will name your wife maybe to be your power of attorney, so then she can take control. And some of the things, these are some examples of what you could name in the durable power of attorney. Any real estate transactions, tangible property transactions, stocks, bonds, commodity, banking, business transactions, insurance, estate trust, beneficiary transactions, any litigation, family, personal maintenance, so benefits from government, retirement, tax, and digital, even your Facebook account, all of that. So these are the examples of the things we like to put in there. Now you don't have to check all of that, but whatever fits your needs. So this is the durable power of attorney. So you have to trust somebody. So this is because you're incapacitated. Either you died, or you're mentally gone, or something serious, you're unconscious, coma, whatever. This is what happens. So this is what you need to do. You need to have persons you can trust. So you need an executor. So the executor is the one that executes the will. What you ask to do, give me one second. What you ask to do in the will, the executor has to do it. Now, the executor can be compensated. It can be anybody. It can be your best friend, it can be your wife, it can be your kid, so I want to say adult. It can be your attorney, it can be anybody somebody you trust.
Okay, durable power of attorney. So when somebody passes away, it's still valid, that durable power of attorney.
So once you pass away, then the estate issues take over.
Estate.
It's when you're incapacitated.
Yeah, okay.
You're still alive.
Yeah, just one.
Yeah. Then the will and all of those other things take over. So the choosing the executive is very important. Now, a lot of times the husband and wife, they will choose each other. But we also like to have second and third options. What if both of you died in a car accident or something? So who's the next, alternate? If the wife cannot do it or something happens to her, then who? You select one of your kids or somebody you trust, your brother, sister, whoever. But think about that. Think about whom you want. First option, second option, third option. Okay? We used to like to put two alternates. So, and then of course the agent of power of attorney. Power of attorney is you're appointing an agent to act on your behalf on whatever you set the power of attorney is for. So let's talk about guardianship. So I'm going to jump quickly through this, but if you have questions, I'll happy to answer. Guardianship is another issue, right? We talked about it a little bit earlier. This is when you take control of somebody elderly, that could be the case, or even, some child who's an adult, but, not 100% mentally developed. So that could be, and so there's guardianship of person. You can take control of all their personal decisions, their health, taking care of them, their medication, things like that. So there's guardianship of person and guardianship of there's guardianship of estate. So guardianship of estate the guardianship is limited to matters of the estate, the business, the money, the bank accounts, things like that. Or you can take both, guardianship of both. So that's guardianship. The way it happens is you go to the court, you have to have the person examined by a doctor, usually a neurologist. They have to give you a form and sign that this person is incapacitated. They cannot make legal decisions. You take that to the court. You have to inform all of the children of this person that they're elderly. They have a right to object or come to court and fight. We are now in a litigation where this is happening. They have 8 children. This lady has 8 children. 7 of them are on one page, taking care of their elderly mother. 1 took the mother and won't return. And it became a big fight. So we're in litigation right now. We go to court. There's a lot of money being spent, but we are now on the verge of winning this thing for our client. And so we're on the team of the 7. We think this one person is really, I don't know what their motivation is, but it happens. And sometimes it's just a disagreement. You're not taking care of mother properly. I know how to do it better. You know, it's as simple as that. So
So do we need a guardianship? Do they have a durable power of attorney? Is that absolutely?
So, durable power of attorney can help with a lot, but power of attorneys can be revoked. So, if they're deemed competent, they can revoke it. So it's not forever. Guardianship, on the other hand, you become there. It's like what kind of control you have over your children. You have absolute control. You can decide what treatment they're going to get, where they're going to go to school. You have full control. That's what guardianship will do. So if somebody is incapacitated, it's better to go with the guardianship. You have more rights. And you don't have to explain to the bank, hey, here's my power of attorney. You don't have to do any of that. You're full control. So guardianship, you can do both. Of the person, of the estate, or both. Okay. Take a sip of water.